Hello and welcome to Topic 3, Lecture 1, where we will be looking at the United States Constitution and the issue of gender equality. So, what will we be looking at in today's lecture? First thing we're going to look at is the issue of equality, the concept, the value of equality, and the role that it plays in American political culture. We're going to look at the 14th Amendment and the Equal Protection Clause that's in the 14th Amendment, since that is basically where equality is seated in our Constitution. And then we're going to look at what unequal treatment and how we determine what is justified and therefore constitutional unequal treatment and what is unjustified, unconstitutional unequal treatment. So that's what we've got on the docket for today. So let's go ahead and get started. Okay, so I teach American government, and one of the things we talk about in American government is how equality is a very important value of the American political culture. At least ideally, we strive to achieve equality. Political culture is just basically the beliefs and values that we have that bind us together as a united nation. And so what it means to be an American is oftentimes to just embrace the American creed, to agree that we make decisions based on what the people want, majority rules, that we think there should be limits on government in order to open up space for people to live their lives in a free manner. And we also believe that people are, as it says there, that we hold these truths to be self-evident, that all men are created equal and they are endowed by their creator with certain unalienable rights. And among these are life, liberty, and the pursuit of happiness. And so that we are created equal and we should be treated equally in the eyes of the law. And so equality is a key value of the American culture. It's embedded in key American documents, such as the quote there from the Declaration of Independence. But as we know that we have not always lived up to the ideal. In fact, the person who wrote the Declaration of Independence owned slaves. And so saying that all men are created equal, he certainly didn't believe that, since he held a vast quantity of humans and treated them as property. And we also know that even though some will say that the word man in the Declaration of Independence was meant to refer to human, let's keep it real. Men was men. And so that even though equality, democracy, and liberty are these values that unite us and continue to unite us, we haven't always lived up to those ideals. However, I'd like to just have you keep something that Martin Luther King Jr. said at the March on Washington in the 1960s, his famous "I Have a Dream" speech. And one of the things he talked about was that the United States is based on this promissory note that we find in key founding documents like the Declaration of Independence, that we are created equal and that we are endowed with these certain rights that we all can partake of fairly, justly, and equally. And that the American project is making good on that promissory note, right? Because once you write those words down, you can't take those words away. The door is cracked open, and the rest of us push that door open in order to make sure that those values that bind us together as Americans are actually, that we live up to those, and that we can promise that we can cash that check or that promissory note, and it will come back with sufficient funds, not insufficient funds, as Martin Luther King Jr. said in his famous speech. And so the story of the fight for equality on the basis of race and sex is part and parcel of understanding what it means to be an American and what makes up the foundation of our American political culture. So, following the Civil War in the United States, the Constitution was amended in order to make the success of the Union in winning the Civil War to actually embed those successes in law. And there were three amendments that were passed following the Civil War, and they're known as the Civil War Amendments. The first one is the 13th Amendment. It abolishes slavery because the thinking was is as Confederate states come back into the Union, if slavery was not once and for all abolished, there would be nothing prohibiting Confederate states from starting up the institution of slavery again. The 15th Amendment was the amendment that forbid denying the right to vote based on race. The amendment that we are most interested in this class is the 14th Amendment, because it's in the 14th Amendment where we find the equal treatment of people before the law. There are different aspects of the 14th Amendment. We'll just go over these quickly. For one thing, the 14th Amendment says that all people born in the United States, even if they were born as slaves, are now citizens of the United States. Okay, so it establishes birthright citizenship in the United States. Another thing that the 14th Amendment does is that it says that states can't do certain things. The 14th Amendment is targeted at states, particularly the Confederate states that are coming back and joining the Union, because we were very aware that now the Confederate states were back in the Union, that they would try to continue denying people who are former slaves of their rights. And so the 14th Amendment is targeted to states. The first part of the 14th Amendment says that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. It's known as the Privileges and Immunities Clause. It's basically saying that former slaves who are now citizens, states can't take away these privileges that all citizens of the United States appreciate by virtue of being citizens. Another thing that it says is that states can't take away people's life, liberty, and property without the due process of law. In other words, if your liberty, your freedoms are going to be taken away, if your life's going to be taken away because of a punishment for a crime, or your property is going to be taken away, the states must follow a procedure to take those things away, right? There has to be a set procedure that all states follow and that all people are subject to in order for life, liberty, and property to be taken away. That's known as the Due Process Clause. The clause that we're most interested in is what's known as the Equal Protection Clause. What the Equal Protection Clause says that states cannot deny any person within the jurisdiction of their state equal protection of the law. In other words, all people need to be treated equally by the law, regardless of whether they're white or black, former slave, regardless of any classification. The question is, as we're going to find, is who does the Equal Protection Clause apply to? Because the Equal Protection Clause is a part of the Civil War amendments, does the Equal Protection Clause, is it targeted to prevent unequal treatment based on race, or does it extend into other kinds of categories as well, such as preventing unequal treatment by the law based on gender? As you'll see in your textbook, the Equal Protection Clause for the first 100 years of its existence was interpreted as to not apply to gender. And that's in part because in the 14th Amendment, there's a reference to men. And you can read more about that in your textbook, and they talk about it in the video you're going to be watching for the discussion. But the bottom line is that even though the Equal Protection Clause is in the Constitution, that it did not apply to women or gender or sex until the mid part of the 20th century. So what is equal protection of the law? Well, it's not an easy question to answer, but let's give it a stab. So equal protection of the law has to do with discrimination, treating people differently, or unequal treatment. And there are lots of examples where people are treated differently by the law. The question is whether or not that discrimination or unequal treatment is justified or not. And if the unequal treatment is deemed to be unjustified, then it is seen as violating the Equal Protection Clause of the 14th Amendment and that law would be considered unconstitutional. If there's a justification for the different treatment, then that different treatment, that unequal treatment by the law, is justified, and it would be seen as not violating the Equal Protection Clause of the 14th, and that unequal treatment would be seen as constitutional. So discrimination is unequal treatment. Well, what is unjustified discrimination? Well, unjustified discrimination is making distinctions between individuals that are irrelevant or with no basis in reason. Here's an obvious example of that. Let's say that there was a law in the books that said only people with blue eyes could vote in the upcoming presidential election or in any election. Well, it's pretty obvious to say that that is a distinction that is unjustified because there's no difference between people who have blue eyes or brown eyes or violet eyes or green eyes. It's just eye color. It doesn't have anything to do with how smart you are or your ability to see or anything. It is merely a visual characteristic that has no bearing on any other aspect of yourself as a human being. So that kind of unequal treatment would be considered unjustified and therefore unconstitutional. There are times where we treat people differently by law, but that different treatment is considered justified. For it to be justified, there needs to be an important or a legitimate reason for treating people differently. And here's an example. There are often times where we have laws on the books that treat minors differently from adults. I teach criminal law, and in my crime class, there's an entirely different judicial system for minors than there is for adults. They are not subject to the same penalties. So minors are oftentimes tried in juvenile court, and the punishments that they can get are much less. Well, why is that? Well, the thinking is that minors are not as developed cognitively as adults. And that is in particularly true when a juvenile is 3 or 4 or 5 or 6. There's no doubt that the cognitive development of a child is vastly different than the cognitive development of an adult. And so the different treatment of minors, whether it's in criminal treatment or whether or not you can buy alcohol or drive a car or fight in the military, as cool as it would be to have a bunch of armed babies, shooting them up, everybody, haha, just joking. That different treatment is justified, it's based on a reason, and it doesn't violate the Equal Protection Clause of the 14th Amendment. The question is how do we determine what is justified discrimination, therefore constitutional, and what is not? And who determines that is the Supreme Court of the United States. And so as you're going to see in the readings for this week, that the Supreme Court plays a huge role in determining what is and is not a violation of the Equal Protection Clause of the 14th Amendment. Some types of unequal treatment are assumed to be unjustified or unconstitutional. Racial discrimination is one of the examples of that. When law discriminates or treats people differently based on race, the Supreme Court assumes that law is unconstitutional because race classification is regarded as a suspect classification. In other words, that because of our long history of discriminatory treatment towards racial minorities, and also because race, like eye color, is an immutable characteristic. We don't choose it. And it also has no bearing on any other traits of being a human. That there's an assumption that when laws treat people differently because of their race, that law is suspect and is unconstitutional. The Supreme Court, when it comes to racial discrimination, uses a very tough standard when determining whether or not that law is constitutional. And it's called the strict scrutiny test. And we'll be learning more about that in the next lecture. What strict scrutiny says is that it's like a red flag to the Supreme Court. When racial discrimination cases come to the Supreme Court where people are treated differently based on their race, a red flag goes up and they say, wait a second, this law is likely to be unconstitutional. And so they put the burden of the proof on the government that passed that law. And they say to the government, whether it's a state or the federal government, they say it's up to you to prove why this different treatment is justified. Furthermore, the court says that the state also needs to prove that this different treatment is related to a very important goal of the state or the federal government. And that the only way they can achieve this important goal is in this unequal treatment between racial groups, okay? It's a tough standard. And as your textbook says, oftentimes when laws receive strict scrutiny, those laws are deemed unconstitutional. Now, other types of unequal treatment are assumed to be justified and therefore assumed to be unconstitutional or constitutional, and they get much less scrutiny by the court. Age is a good example of that. We used that example on the previous slide. Treating people differently based on their income, particularly as it relates to like getting a mortgage, right? I mean, like you have to have an income qualification to get a mortgage, but you also have to have an income qualification to be eligible for food stamps and other sorts of income support laws. And treating people different because of their citizenship status. Non-citizens can't vote. All of those are all examples of categories where people are treated differently, but it doesn't raise a red flag for the courts. And when those kinds of cases come to the Supreme Court, age, income, citizenship, it's not deemed as a suspect classification, and a lower level of scrutiny is given to that different treatment, and it's called the rational basis scrutiny. The state just merely has to show that the different treatment is based on a legitimate goal of the state and that there's a reason for that different treatment, that it's not completely and utterly arbitrary. The question is where does gender fall into this? What about gender and sex discrimination? Should gender, when people are treated differently based on their sex or gender, should it be treated like a suspect classification, much like race is, and should it receive strict scrutiny from the court? Or is gender, should it be treated, when people are treated differently because of their sex, should it be treated like a less suspect category, sort of like income, age, and citizenship? Okay, so when it comes to different treatment by law of men and women, I want you to keep these things in mind when you're reading through the cases in particular. Are there justified reasons for treating men and women differently? Maybe ask yourself, how are men and women different? And are these differences based in fact? Are they real? Are they meaningful? Are those differences substantial? Or are these differences not based in fact? Are they based more on stereotypes? Are these differences arbitrary? Are they or the differences are there, but they're not of great importance? Are they manufactured through socialization and reinforcement in the media? And so sort of keep those things in mind when you're thinking about different treatment by law. There are some real and meaningful differences between men and women, most of which revolve around biology and the differences regarding reproduction and pregnancy. But there are also differences that are really not very substantial or are also not based in fact and mostly just a product of stereotype. For example, the notion that women are more cooperative and men are, need to fight things out aggressively and they're not willing to, cooperate. That's not based in fact. That's just based on socialization and reinforced by stereotypes. similar to the notion that women are nurturing and gentle and need to be protected, and men are, the go out and the breadwinners and not capable of nurturing, so they shouldn't be around the kids, right? Well, those are not based in fact, and those are based rather on stereotypes. So try to keep that in mind, between the substantial and the real differences between men and women and those that are mostly based on stereotypes. In conclusion, that the answer to is different treatment based on gender and sex justified? The answer to that is a very important question. How we answer that question has huge impact on civil rights law, and also the policies that we have in the United States. And as the answer to that question about whether different treatment is justified changes, so does law and so does policy. And you're going to see, how that those differences and how that takes place, throughout of the course of the readings that you're going to be doing for this topic. And we have, just to end here with a shout out to, Justice Ruth Bader Ginsburg. Um, as you are reading the textbook, they have long excerpts about her life because, Ruth Bader Ginsburg, while obviously she was an excellent, Supreme Court justice and wrote the opinion in the Virginia Military Institute case, which you're going to be reading about this week. She started her life in law as a litigator, and as a litigator fighting for, challenging laws, that treated men and women differently, challenging those, making the case that that was a violation of the equal protection laws, the Equal Protection Clause. And you're going to see that she won in many cases that you're going to be reading about this week. So, there's no better time, although I wish it was under different circumstances. I wish she were still alive. But that it's even more meaningful when you look at the impact that her life and her, life as a lawyer and then as a justice, the impact that that had on our understanding of, equal protection of the law on the basis of sex. Okay, thanks for listening, and I'll talk to you again soon.